Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. Today I wanted to talk to you about durable powers of attorney and the need for special powers and how to comply with Florida law when trying to give your agent special powers to act on your behalf. I recently had a family come to my office. They brought with them their power of attorney that they had in place for their mother who was suffering with a dementia diagnosis. Generally speaking, durable powers of attorney are where we start with as elder law attorneys when we look to put safety nets in place for people who wish to age with grace and dignity and protect their legacy. So this family brought to my office the power of attorney that they had in place. It was prepared in a different state. They had this prepared when they lived up north, and now they were living here in Florida. And unfortunately, the power of attorney that they had did not, it was very limited. It did not have special powers that are really important when we seek to do some long-term care planning, particularly for people who do have diagnoses such as dementia. And so you might be wondering, what are these special powers that you're talking about, and why is it so important? So in Florida, powers of attorney have to have a special initial next to certain powers that are considered special powers, and that is the power to create trusts. So if you want your agent to be able to create and change trusts on your behalf, whether they're revocable or irrevocable, and whether you as the principal would be a beneficiary to this trust or not, that would be a special power that you would be giving your agent, and you would have to initial next to that paragraph in your power of attorney indicating that you want your agent to have that special power. Another special power is the ability to disclaim. So should you inherit something that is not really beneficial to you, and actually it would cause you more financial harm to have that gift than it would be to simply disclaim that gift. If you want your agent to be able to say, to disclaim that gift, that is a special power that you have to initial next to say you want your agent to have the ability to disclaim gifts. In addition to statutory elections, particularly when we're speaking of the Florida elective share. So if you want your agent to be able to have the opportunity to disclaim such things, that's a special power. Another area is annuities. If you want your agent to be able to make changes to annuities and retirement plans that you have, if you want your agent to be able to engage in certain gifting powers or otherwise engage in other long-term care planning needs, those are all special powers that next to each paragraph within your durable power of attorney, you as the principal would need to initial and say, yes, I want my agent to have that authority. So this family, the power of attorney that they had in place that was created for their loved one didn't comply with the requirements, and we weren't able to use their power of attorney to accomplish some of their goals. And unfortunately, it wasn't just goals here in the state of Florida. They had their loved one owned property in Puerto Rico. The power of attorney wasn't written in such a way that they could effectuate certain real estate transactions that they wanted to also accomplish in Puerto Rico, because the document just didn't cover that. It just didn't. The authority just wasn't there. And so, unfortunately, this family, based on their loved one's diagnosis, was left only with guardianship as an option, which is a whole court proceeding where you have a guardian appointed on behalf of your loved one, and there's court supervision and additional costs and monitoring that are involved with the guardianship process that we all seek to avoid through very strong and thorough durable powers of attorney. If you are a person that likes to do your own legal research and Google what these special powers are and what I'm talking about, feel free to search the Florida statute, chapter 709, section 2202. And I encourage you, if you're the type of person that likes to buy forms off the internet and do it yourself, to really proceed with caution when you are using a form for your durable power of attorney, because you don't want to find yourself in a predicament, or your family in a predicament, where the paper really doesn't accomplish your ultimate goals and doesn't meet your ultimate needs. Therefore, I always encourage you to at least seek a consultation with a Florida elder law attorney to assist you and your loved ones in this process, so that should you find yourself in need of a strong document, that you actually have one. Of course, if this information is helpful to you, I encourage you to like and share with others, and I thank you for joining me.